This is attorney Sarah Holmes of Holmes Business Law PC, and today's presentation is on commercial leases, negotiating and renegotiating terms. All right, so first, before we get into the substance, let's just do a quick who we are, why we're talking to you today. So Holmes Business Law PC is a business law firm. We do things like help people negotiate commercial leases, entity formation, investor agreements, trademark registration, contracts, hiring employees, and basically transactional business legal needs. I'm Sarah Holmes. I'm the managing attorney. We have several staff. We have 2 paralegals. We have an associate attorney and myself. I've been a business owner for, about 11 years now. The first business I ever had was a business I started in my kitchen. And then I had a retail business at one point, and then I had my law firm. And I started my law firm because when I started that first business, even though I had been an attorney for some period of time, I used to do litigation work. So I used to defend businesses from claims and lawsuits. And when I actually went out to start my own business, even I was confused as to all the legal help I needed. What did I need to do, in what order? And at that time, there weren't a lot of attorneys focused on small business owners and willing to help. So I decided to found a firm dedicated to helping small business owners, entrepreneurs, and this is all we do, the only type of people that we help today in our law firm. We also provide a lot of general counsel services. That is, a corporation will often have inside general counsel. It's an attorney that they pay directly on their payroll that works exclusively for them. That's something that's normally cost prohibitive for most small businesses. So what they can do is something called general outside counsel, which is you have an attorney on retainer or a law firm that you pay to be your outside general counsel. And then any legal business issues you come across, you call your general counsel. They can either help you or refer you to a specialist depending on what type of issue you have. And that's a lot of the services that our office provides to existing business owners. All right, so first of all, let's talk about some basic lease terms, just for people that maybe are unfamiliar or have never leased commercial property before. I've taught a number of CLEs on commercial leases. Those are educational classes to other lawyers for continuing education credit. In fact, I just taught one in the fall. I represent a lot of tenants in commercial lease transactions, meaning I will represent the business owner that's going to go lease space for the first time. And one thing that people are generally really surprised about is how different commercial leasing is from a residential lease. So for example, a residential lease will have a lot of protections for the tenant. For example, it's very difficult, especially in big cities, to evict a residential tenant. You have to go through a whole process. Sometimes there's a mandatory mediation. Generally, the rent has to be in arrears for some period of time. Commercial is the opposite. It's whatever you can agree to in that lease with the landlord. And the law presumes that if you are a business owner, that your negotiating power is no different than the landlord's. Now, that might not quite be true, especially if you're thinking about renting some type of space from a giant corporation or a big landlord. Clearly, you might feel that you are not as powerful in that transaction. However, the law doesn't view it that way. So therefore, your lease and your protections are only as good as what you can negotiate during that lease transaction. So what are some basic lease terms to think about? Number one is always, what is the rental rate and what is it based on? There's something called a triple net lease, which is also NNN, or there's a gross lease. Gross lease is they're not charging you any additional rent per month. They're not charging you any more money. The amount of money that they show you that you're going to pay every month is generally what you'll pay, maybe with the exception of some utilities, like you're going to pay your own electric, or often internet is something that's excluded. Triple net is going to add, in many cases, a good chunk of change to your monthly rent. And the triple net is stuff like local taxes, use and occupancy taxes, it's common area maintenance charges, it's the landlord's insurance for the building. Those can really, really add up. Some people are surprised because it may, in fact, add, for example, another $1,000 to their rent rate. So, especially if you're in a city and you see a rental rate that looks low for the area, be warned that it may look low because the triple nets are going to add a big chunk of change onto that rental. And now the triple nets change every year, or they can change because often the operating expenses for the landlord go up, the insurance goes up, property tax is definitely something that goes up. So you really have to pay attention to those triple net numbers and what they are. Often, if you're working with a broker to look at a space, for some reason, they might not think to disclose to you at the outset how much those triple nets are going to be. And so when you make an initial offer to the landlord of what you're willing to pay, you might be offering something that really is your bottom line. And then once they accept that and come back and tell you now they're adding the triple nets on top of it, you might say, well, hey, I feel like you sort of deceived me because I clearly would have offered you much less money for the rental rate if I knew upfront that these triple nets were adding so much to it. So be very careful and very specific about what exactly you're going to be paying in rent every month, because often it doesn't look like what it is on paper. Commercial leases too tend to express rents as a dollar amount per square foot. So for example, if you're going to rent 1,000 square feet of of space, and that is priced out at $35 a square foot, your annual rent is going to be $35,000 a year. You divide that by 12, that'll get you your monthly rent that you're going to be paying. And again, that's likely without the triple net costs added back unless it's a gross lease. All right, the second thing that when you go to lease commercial property, you're going to be aware of is clearly what is the length or the term of the lease, meaning how long are you locked into this deal? Commercial landlords will try to lock you into a longer deal. It's better for them. There's consistency to it. If they need to refinance the property, it's going to be much easier for them. If they can show the bank they have a bunch of tenants locked down for a long period of time. So typically in a commercial lease, you're going to see landlords ask for normally a minimum of 3 years. Often they'll try to push you to 5. Once in a while, we see someone trying to get a 10-year lease. If you are a startup or beginning business, we rarely would recommend that you go into a 3-year lease at the outset. It does tend to be a long time. Often, though, they're not going to agree to something less. So if it's between a 3-year and a 5, I would certainly, in most scenarios, be hesitant to recommend a 5-year lease to someone starting out. 3 years is kind of for a new business owner, the point at which you're going to make it or break it, meaning after 3 years, this business is doing well, it's rolling along, things are going swimmingly, and now I've decided I want to stay in this space. And you can commit to then a longer period of time or a renewal period. Or at the end of 3 years, I give it my best shot. I hate doing this. I want to get out. I want to fold my cards up and go home. So you'd be surprised. Also, if your business is going well, it might be that after 3 years, you need more space. Maybe you rented space that wasn't quite enough for you in the beginning, and you hadn't planned on growth. That's a good problem to have. But the point is that at the 3-year mark, you would certainly have some options available to you if you did not initially go into a longer lease, like say a 5-year, and certainly not a 10-year lease. Parties, what does that mean? Well, that means whose names are on this lease? Who is the lease between? The landlord, I can guarantee you 99.9% of the time, the landlord is a business entity. It's not some individual person. So it'll say, XYZ Corporation or 123 Main Street LLC, whatever kind of entity that landlord has that business, or has the property in. That's likely the landlord identified on the lease. Now, a tenant, this makes a big difference. If you are a starting out new business owner, they might initially have your individual name as a person listed on that lease. That's a big difference than if it's the name of your LLC on that lease. If you've set up an LLC and you're in business already, or if you're an experienced business owner, it should be the name of that LLC on the lease. And that you'll see on another slide in terms of the remedies and the defaults makes a really big difference as to who is going to be on the hook for this lease. If there's a notice of default, if you are sued, if something happens under the lease, who is it that they're going after? Is it the business entity or is it one of the owners personally? You have to be very careful about who's identified as a party on that lease. All right, what are some other terms? So other things that we typically see in a lease are sublease, the right to sublet. Often people, that's their sort of backup plan / out. Well, if I rent this space and it doesn't work out for me, it's fine because I'll just sublet the space. Well, you have to look carefully at that lease because 9 times out of 10, there's going to be a clause in that lease that prevents you from subleasing the space, or at least prevents you from subleasing it without the landlord's approval, without the landlord doing a credit check of the new tenants. And even if they do all that stuff and approve a new tenant, chances are that lease has language in it that still makes you, as the original tenant, on the hook until the term of your original lease is expired. So very, very carefully, you need to read and negotiate sublease clauses. Now, another thing we typically see is pre-possession work. That means, hey, I saw this space. It's not quite what I need it to be. There would need to be a lot of work done to it. Who's going to do that work? Who's going to pay for it and be responsible for it? If the landlord wants your business enough and you seem like a good enough tenant, and they think it's a good enough investment, sometimes a landlord will agree to do that work. Now, whether the landlord is agreeing to do the work and paying for it, that's a separate question. Often what the landlord will do is agree to do the work, but somehow you're going to pay for that. Whether you're paying for that work because the rental rate is higher, whether you're paying for that work because it's tacked on to your monthly rent payments, chances are the landlord's going to pass the cost of work onto you, the tenant. Now, if it's something fairly simple that the landlord would have had to do anyway, just to get the place rented, they might do it and eat the cost. For example, if you're going to rent some type of space that's new construction, right? The landlord's going to have to finish that space in order to rent it. So chances are they'll deliver it as something called vanilla box, meaning most of the time they finish the floors, the walls are up and drywalled, the ceilings in and drywalled, and there's some basic kind of builder grade light fixtures installed. If you want anything custom, if you want anything more specific, often if you need plumbing installed, that would not be part of the vanilla box. And that is stuff that you'd have to pay for as an upgrade, or you'd have to bring in your own contractor and pull your own permits and do that type of work. So if there's any type of work being done before you move into this space, all that stuff needs to be spelled out in the lease, even if you as the tenant are the one that's going to do all the work and hire your own contractor. The landlord will usually need you to pull the permits and approve what work is being done. So you might need to submit some drawings. You might have to give them a plan of what you're going to do. And you're going to have to make sure that you use licensed and reputable contractors. And it's not, like your brother-in-law coming in and demoing and doing the drywall. Often that's not going to fly in a commercial space. It might save you a lot of money, but the landlord is very concerned about liability and the work being done properly and people being able to place liens. So they want to make sure that you are using contractors that are totally legit and licensed and properly insured. Now, the other terms that we always look for in a lease are the renewal terms. So that is, all right, let's say you go into an initial 3-year lease. What happens when the 3 years are up? You can either renew, and then that lease would either go, maybe it renews on an annual basis. Maybe after the 3 years is up, you're going month to month. Maybe after the 3 years is up, you want to negotiate a longer 5-year term for your next stay in the space. And right now, maybe you want to lock in a really advantageous rental rate that you're going to start paying for that next term. And normally, if rents are going up, if you're able to negotiate a lower price now, you'd be better off. Now, if something crazy happens, like, I don't know, there's some financial depression, financial crisis, and at the end of 3 years, that rental now market rate is much below what you would have paid, then in that instance, it would have been better to wait and negotiate the renewal terms. So it's certainly hard to say, and you really want to factor these things in when you're discussing rental terms and what you're willing to pay for the next chunk of time you're going to be in the space. Now, how bad things can happen in a commercial lease. There's a lot of things that can go terribly wrong in a commercial lease. that can subject you to personal liability, that can subject you to just a crushing amount of debt and liability if you default on a lease. So, what are some main ways that bad things can happen when you're in a commercial lease? So, number one would be having a personal guarantee. Now, if you are a new business owner with no history of revenue, you have no tax returns, you are just brand new, untested, unproven business owner, rarely are you going to find someone willing to lease you commercial property without giving a personal guarantee. The personal guarantee means that even if they agree to put that lease in the name of your LLC or your business, there is still a section that you're going to have to sign that says that you are the one personally backing that lease, such that if you default, it's not the business that they're going to sue, or they'll sue the business in addition to, but you are the main person agreeing to guarantee that lease. So that means if you default and they get a judgment, they're going to look for your personal bank accounts, your personal assets, and they would be able potentially to reach those things if you are the one personally guaranteeing that lease. Now, we've seen some leases where the person is so untested, maybe they're very young, and the landlord's requesting a spouse to also be on the guarantee, or a landlord is also requesting parents to be on a guarantee. So now that guarantee is not just all those bad things to you personally, but whoever else is agreeing to go onto that lease with you. In those situations, we talk very carefully with clients about the ramifications of that, not only for them personally, but for their family members or whoever else is agreeing to go onto the lease with them. All right, the second bad thing is a confession of judgment. This is particular to certain geographic areas of the country, Pennsylvania being a big one. In other areas, they do not do this. And in some places, this is not even legal, but it certainly is in Pennsylvania. And again, you will rarely find a commercial landlord that does not put this in one of their leases. Confession of judgment means that you have waived all of your constitutional rights and that someone can get an automatic judgment against either you or your business if you default under this lease. And there's two different types of confession of judgment. There's one that is for possession, meaning they're going to get the property back. And two is for money damages, meaning the amount that you have left on that lease, accelerated forward, plus costs, plus attorney's fees, that number just balloons up and up and up. So confession of judgment is very bad. Again, you're waiving your constitutional rights. You would not have a right to present a defense at a hearing. You wouldn't even have a hearing. You couldn't even get a lawyer to defend you. It's literally an automatic judgment. They take a paper to court and they get a judgment. And combined with it being the money damages and the rent accelerated and a personal guarantee, sometimes this potential liability exposure, depending on what kind of space you're renting, is in the multi-hundreds of thousands of dollars. So if that's something in your lease, which again, 9 times out of 10, it probably is, you want to get an attorney, you want to get somebody to help you negotiate that and figure out the best way to mitigate that and blunt that against it being personally devastating financially for you. And there's rent acceleration. So I just described that in the context of a confession of judgment for money damages, but rent acceleration is exactly like it sounds, meaning let's say you signed a 5-year lease. In year 2, things aren't going well for you and you have to go out of business. You don't just owe them the money for the rest of year 2, they're going to accelerate the rent and you owe them now the rest of year 2 plus years 3, 4, and 5, which again, if you're paying, a good amount of money per month in rent, that could be a huge figure, often combined with fees, collection costs, attorney's fees. You really have to read these clauses carefully to figure out what your maximum exposure could be, because in most cases, it's pretty significant. All right, how can you renegotiate a lease and what things should you renegotiate? Well, last year, when COVID happened, renegotiation of leases became a very big issue because most people were subject to a stay-at-home order. Anyone that had an office was basically ordered to work from home along with their staff, meaning that if you had rented commercial space that was now sitting empty, many people had a drop in their business, especially we have a lot of clients in fitness. Those people were not able to have anyone in their spaces. They weren't running fitness classes. Small retail was closed at the beginning if it was non-essential. Eventually that moved to just outside curb pickup. So these are commercial spaces that were sitting vacant for a period of time, and not only sitting vacant, but also in many cases, it was near impossible for the owners of these businesses to be making money while they were sitting vacant. And that was through no fault of their own. That was due to a government order. So renegotiation of a lease became a big deal because many people clearly had trouble paying their rent. It didn't make sense anymore to be renting empty office space. It didn't make sense to be paying rent on a fitness space if you're not allowed to have people in there doing fitness classes. And it took a very, very long time for these things to come back. And even a year later, they're only now very slowly coming back. And even in the city, coming back even more slowly. So it was definitely a time to renegotiate a lease. So when we renegotiate, what are we looking at? Well, number one would be a change in financials, such that when you initially rented that space, your financials presented one way. Now, maybe through no fault of your own, your financials are not doing well and you need to change some lease terms. It may, in fact, be better for your landlord to renegotiate with you and keep you in that space. If you've been a good tenant, if you continue to pay on time, they'd be better off getting a lower rate from you for the rest of the term of your lease, rather than risking you defaulting, having to find a new tenant, having to collect a judgment from you. It may be in their benefit, in fact, to renegotiate with you and discuss a different rental rate due to a change in financials. Most leases are going to have a force majeure clause. And if that lease was issued before last year and you didn't have an attorney helping you, chances are the force majeure clause did not help you as a tenant, because the force majeure clause likely said something like, due to an act of God, I don't know, a hurricane, a terrorist attack, something like that, something out of everyone's control, the parties would be excused from their obligations under the lease, except for the tenant to pay rent. So that was pretty shocking to a lot of people, to find that the landlord would be excused from having to provide a suitable space for you to conduct your business in, yet you were not excused from paying rent. People now have hopefully largely learned their lesson. And when they enter into new leases, we address that in the lease. And we say something like, if this business is closed due to a government order, during the period of time it's closed, this tenant is not going to pay rent. That rent will be abated, or you're going to agree to either extend the lease term, or you're going to agree to chop up the rent balance and add it on over the rest of the term. So force majeure was something that probably since 9/11, people hadn't paid a lot of attention to. And now post-COVID, they're going to be paying a lot of attention to make sure that if something like this ever happens again, or the government closes your business against your will through no fault of your own, that you're not stuck paying rent that whole time that your business has to be closed. Renewal might be something that you're able to renegotiate if, let's say, again, you signed an initial 3-year term, and on the front end, you maybe asked for 5 years, but you didn't negotiate the rental rate. Maybe you agreed to a personal guarantee initially. That's stuff that now, several years in, if you've been a good tenant, again, if you're paying your rent on time, they want to keep you in the space, they're probably willing to renegotiate with you on the renewal, maybe give you more favorable terms, maybe do some upgrades in the space for you, maybe take you off the personal guarantee, things like that. Once you've proven yourself as a tenant, you're doing well in your business, the renewal and the renegotiation can look a whole lot rosier for you as a business owner. All right, so conclusion, basically, again, commercial lease is totally different than a residential lease. You do not have the same protections by law that you would have as a residential tenant. Most of the time, it's whatever you can negotiate, your negotiating power. So it's very important to know what to negotiate, what you can ask for, how you ask for it, and ultimately how it ends up being worded and inserted into your lease. If you need help, we have a great team available, both myself, my associate attorney. You can feel free to reach out, call, or email our office. The phone is 215-482-0285. And the email's the info@phillysmallbusinesslawyer.com. So we're happy to help you with your commercial lease. I hope this was helpful for you, and certainly good luck in the future with any business expansion and getting into a great space that fits your business.